Ready to record.
Thank you. Good morning. The appellate court is back in session. For the record, we are conducting this hearing virtually via Teams and are live streaming this hearing on YouTube. Counsel are advised, to the extent that there is statutorily protected parties and or information here, that you take extra care not to reveal said protected information. I would ask that everyone participating in the hearing identify themselves, starting with the judges, then counsel for the appellant, and finally counsel for the appellee. I am Judge Elgo.
I'm Judge Cradle.
Good morning, Judge Clark.
Your Honor, I'm Michael Ziska, rep from the firm of Halloran and Sage, representing the defendant appellants.
Good morning, Your Honors. Attorney Joshua Schulman from Beck and Eldergill, representing the plaintiffs' appellees.
All right, thank you very much. For the record, I note that I can hear and see everyone. Please let us know if in the course of your argument you're experiencing any difficulties hearing or seeing the participants. If you should lose your audio or video capability, please log out and retry the Teams link that you were sent for purposes of this hearing. In that event, we will take a pause in the proceedings. All participants must keep their video on and remain in view throughout the course of the proceedings out of respect for the process and the participants. All participants are also asked to keep your microphones off and muted when you are not speaking. The judges will raise their hand if they have a question to avoid talking over whoever is speaking, but will interrupt if you for some reason do not see them. Please keep in mind that while this is a virtual hearing, all participants are expected to conduct themselves with the same formality and respect for the process as you would in our courtroom. Each side will be permitted 20 minutes of argument. The appellant may reserve a portion of that time for rebuttal and should advise me before you begin how much, if any, time is requested for rebuttal. Judge Cradle has kindly agreed to be our timekeeper and will give you a 2-minute warning and also let you know when your time is up. So this is the matter of Robinson v. TINDILL, docket number 43995, and counsel, you may proceed.
Thank you, Your Honor. It's a pleasure to be before the court this morning. I would like to reserve 4 minutes for rebuttal, if I may.
All right, got it.
Thank you, Your Honor. I know, given the brief time available for argument and knowing from experience that the court always does a very thorough job of reviewing the briefs and the facts, I will not go into a recitation of the facts in this case, but will instead concentrate on the argument and those facts that I think are particularly pertinent to the argument. This is essentially a tale of two fences. Unfortunately not by Charles Dickens, but nevertheless, that is what this case is all about, two fences. We're going to start with the first one. The first one is a split rail fence that the center line of the split rail fence is dead on at the street line. It's exactly where it should be at the street line, meaning it's centered on the property line. But as the fence goes back between the properties, it actually diverges by an angle of less than 1 degree over a course of about 41 feet, so that at the very end of that split rail fence, the center line of the fence is 3 inches off the center line or off the property line. And that variation is into the Tindills or into the defendant's property. So to put this in a nutshell, the question is, if under state law, under the fence statutes, a fence that was created exactly on the property line would not be a trespass, how can a fence that is moved slightly further into the defendant's property constitute a trespass on the plaintiffs? It makes no sense, and it is not required by state law. And it was error for the trial court to find that it was a trespass because it diverged into the defendant's property. Section 1-2Z of the general statutes requires a court to consider, in determining the meaning of a statute, first of all, its relationship to other statutes. And after examining that text and that, yes, I'm sorry, Your Honor, go ahead.
Counselor, I guess I'm a little confused. Are you suggesting that the fence, the split rail fence at all times is either on the boundary line or on your own client's property?
That is correct.
So at no point does it actually go over the boundary line in any respect into the plaintiff's property.
The center point of the of some of the posts go onto the plaintiff's property under section 47 -43 of the general statutes. The center line of the divisional fence is supposed to be right on the property line. In other words, the divisional fence is allowed to go onto the other property, but it's supposed to be half and half. It's supposed to be a shared burden. In this case, the center line of the property line is exactly, or the center line of the fence is exactly right at the street line, but as it moves backward between the properties, it goes further into the defendant's property. So it's less on the plaintiff's property than it would be if it were fully properly aligned, according to the statute. Less of it is on the defendant's property, or on the plaintiff's property rather, than it would be otherwise.
But
Yes,
sorry, if I could just follow up, Judge, I'll go quickly. Just the statute, to the extent we agree at all that this is in fact a divisional fence, which obviously is disputed among the parties in their briefs, but if we assume it is, I mean, it's, as you just conceded, it's supposed to be at most, equally on both property owners' property. I'm a little confused about what your position is. I'm sorry. I remain a little confused about what your position is with respect to whether or not at any point this fence deviates from that requirement and intrudes more into the plaintiff's property than contemplated by the fence statute.
Actually, Your Honor, it intrudes less into the plaintiff's property.
No. I don't mean as a whole. I mean, at any given point, does the fence intrude more onto the plaintiff's property than is contemplated by the divisional fence statute?
No, at no point does the fence intrude more into the plaintiff's property than would be allowed under state law.
And is that consistent with what the trial court found, or is that just your argument?
No, that's consistent with what the trial court found. Your Honor, the only, I'm sorry, go ahead, Judge Elgo.
Well, I think what I'm unclear about, and maybe this is part of what the confusion is, at least from my point of view, let me just speak for myself, is that I understood the argument before the court as one being in which the characterization of this fence, at least now while it's in litigation, is that it's a divisional fence, and therefore it is not a trespass because a divisional fence is allowed. And so the dispute before the court was whether it was a divisional fence. And so that is what I understand what was being litigated, because so not that it is less of a trespass because most of the fences, or at least some portion of it, is on the defendant's property, right? So the theory before the court in terms of rationalizing what the court ultimately determined as a trespass was because it was being now defined as a divisional fence, correct? That's what was before the trial court.
That is correct, Your Honor. That is correct. And
if the court, so isn't this dispute whether or not it's a divisional fence? Because that's what I want to hear is how do we get to the point of it being a divisional fence? Because that's how the court rationalized.
This is not, well, it's not precisely that, Your Honor. Certainly that's a major issue. Is it or is it not a divisional fence as contemplated by the statute? But the other question, and I think the more important question, is even assuming that it's not a quote unquote divisional fence as precisely defined by statute, is trespass a correct conclusion? Is that the proper remedy in such a case? And we think that's where the trial court erred.
But doesn't it, I mean, if it were truly a divisional fence, then it wouldn't be a trespass, right?
Correct.
Okay, so that's how you're trying to get past the trespass, is to call it a divisional fence, right? That's how it was presented to the court.
Not precisely, Your Honor.
Okay, I'm sorry. All right.
Yeah,
how
not.
How was it argued before the court then?
The argument before the court was that, well, certainly there were two parts to the argument. First of all, that it is it is a divisional fence, even though it doesn't meet the precise geometry of 47-43. It's still a divisional fence. But secondly, even if it's not a quote unquote divisional fence even if 4743 does require that kind of thumb-numbing exactitude in location, it's not a trespass if the intent is to create a divisional fence, if the fence does not intrude further into the plaintiff's property than the law would allow if it had been correctly aligned, and that it can't be a trespass if that doesn't occur.
Now, correct me if I'm wrong, because doesn't the requirement for divisional fence require some consent or permission on the part of the other property owner, the adjacent property owner?
It does not, Your Honor.
What is the requirement there?
The statutes allow, well, the statutes create a system under which both sides are supposed to equally share in the location, the construction costs, and the maintenance costs of the fence. That's the statutory ideal. It set up a system where a fence was supposed to be created. There was an obligation stated in 47-43 for both sides to have a divisional fence. And the goal of the statute was that nobody would be burdened more than, no one party would be burdened more than the other in the creation or maintenance of the fence. And that's the reason why it's supposed to be on the property line, so that no more of the fence hurts one side than the other, and no more of the fence is maintained by one side more than the other. But
so doesn't that statutory construct suggest that both parties are then therefore in agreement, and that's why you don't have a trespass? Because the assumption is that both parties are essentially involved in the fact of the divisional fence.
Except, Your Honor, there are a number of statutes that specifically allow any one landowner to create the fence. There, 47-49 allows one landowner to take the initiative to create the fence. It may be just, in some cases, one landowner doesn't want to build the fence, just doesn't want to do it. So one landowner under the statute can take the initiative to do it. Now, they're doing it to some extent at their own risk, because if they do it in a manner that the neighbor doesn't like, then the neighbor can take some action about that. But the action that the neighbor is supposed to take under the statutes is to go to the fence viewers, to the municipal fence viewers, not to go to court, but to the municipal fence viewers. And then the municipal fence viewers have a variety of things that they can do to make adjustments. They can require the fence to be changed in nature. They can require it to be changed in location. They can require all sorts of things. And as we pointed out in the briefs, they can even allow the fence to be a bigger fence than the statutes would provide for. Yes, Judge Eldo.
Thank you. Is that their only remedy? Does the statute suggest that that's their only remedy, is to go to the fence viewers?
We believe that as the courts have said in other cases, when there is an administrative remedy that's available to be used, that should be used before proceeding to court, that there's no jurisdiction in the absence of that. Yes, Judge Clark?
I didn't mean to interrupt, Judge Elgo. Did you want to follow up, Judge?
No, please go ahead.
I mean, your exhaustion remedy only works, though, I presume you concede, if we find it is in fact a divisional fence, right?
No, we don't believe that's correct, Your Honor. We believe that the statutory system allows a correction of any fence that is intended as a divisional fence. Your Honor, please recall that these statutes were created over 2 centuries ago, and it's very, very unlikely, and I do see your hand, Your Honor. I apologize. I just want to finish this thought. It's unlikely that the legislature would have assumed back then that fences were always going to be placed dead on the center line. And we believe that the statutory system is to allow any corrections in these fences if they're not exactly as the statute requires. I'm sorry, Judge Clark.
Is your client and the plaintiff, are they proprietors of land for purposes of the fence statute?
Erica TINDILL is the owner of the property. William TINDILL is the person who built the fence. There's no evidence. Okay. Yeah, there's no evidence. I'm sorry, Your Honor.
The statute is what I'm asking about now.
Oh,
So the statute, the statute speaks to a number of different types of property owners. It speaks to proprietors of land in the first sentence, and fields. Okay, and then it goes on to speak about residential abutting and adjoining landowners. And I'm just trying to understand, is there a distinction between proprietors of land in that statute? Is that distinction meaningful in any way as a legal matter? Proprietors of land and fields, and what kinds of fences and remedies are in play there versus residential landowners? Because your argument is that every owner, every owner of land in the state, it seems to me, is your argument is legally obligated to have a divisional fence because of the word shall. But that shall only appears in that first sentence with respect to proprietors of lands and fields. And I'm just trying to get my head around that statute and whether it really meant, because then it goes on to speak about a different class of landowner and divisional fences where it doesn't use the word shall anymore, and it's just talking about abutting neighbors.
I believe that although I can't prove this, Your Honor, I believe that the statutes were probably, when they were originally created, were just a running set of statutes without all of these sectional divisions in them. And as occurs frequently when statutes are recodified and they get divided up into numbered sections, some of the numbered sections no longer refer to some of the things that were in the earlier sections just because everybody knew what they meant at that point. We think 47-43 was the beginning of the statutes that applied to, thank you, Judge Cradle, that applied to all landowners, and that as the statute progressed, and now as the statutes go forward in numerical order divisionally, it makes clear that they apply not only to just farm fields and open fields and fields with animals, but also to residential houses as well.
And what about this chain link fence? Because that was a separate issue that we haven't talked at all about. Was that a divisional fence?
Again, there's no evidence to show where that is. And that's one of the interesting things about this case. The survey doesn't show that that's on the property line, and yet the trial court said, well, that's a divisional fence. But how could the trial court say, well, it's not a divisional, the split rail fence is not divisional because it's not on the property line, and yet find the chain link fence to be a divisional fence with no evidence that it's right on the property line, as opposed to being slightly into one property or another. But the more important aspect of the chain link fence, Your Honor, is that there was never a claim made about, there was the court's finding that it constituted conversion. That was never pleaded. It was never pleaded, it was never argued, and the trial judge never asked about that during oral argument. Judge Elga?
Yeah, with respect to the conversion count, quote unquote count that was found, I'm assuming, I didn't see in the complaint that there was any request for damages pursuant to any kind of conversion claim, correct?
Correct.
All right.
And in fact, Your Honor, the plaintiffs acknowledged that there was no damage to them. There was no injury.
Okay. All right. Thank you.
Okay, but your position, though, is that the split rail fence is a divisional fence and that there was no evidence either way on whether or not the chain link was one, and therefore the plaintiff couldn't prevail. Of course, if it were a divisional fence, you'd have a problem, it seems to me, right? I mean, because the statutes that you are relying upon here would have required you to get some sort of permission or go to the fence viewers before making any repairs, right?
May I answer the question?
Yes, yes, you may. Go ahead.
Thank you. Your Honor, our claim is that it is a divisional fence, even though it is not properly aligned. It's still a divisional fence. If it was not—
fence? Which fence?
The split rail fence, I'm sorry.
Okay, but the chain link fence, yeah. It's your position that is not, or at least it wasn't proven to be one, and therefore the requirements under the fence statutes about repairing divisional fences didn't apply to the chain link fence, right?
What we're saying, Your Honor, is that it was inconsistent of the trial court to find that the split rail fence was not a divisional fence, but that the chain link fence was. Our argument is that both fences were in the nature of divisional fences, and the fence statute allowed William Tyndall to make adjustments to the chain link fence as a divisional fence, and also to establish the split rail fence, and that the remedy for any inaccuracies in that was to go to the plaintiffs to go to the fence viewers, not the court.
I guess I'm a little confused about why one requires exhaustion of remedies and the other one doesn't, but that's fine. Let's.
All right.
Yeah.
Okay. Thank you. I know that your time was up, but you can have your full, what was it, 4 minutes that you requested?
Yes, Your Honor.
All right. You'll have your 4 minutes upon rebuttal. All right. Attorney Schulman.
Thank you, Your Honor. I want to start by clearing up something that opposing counsel frequently talks about in his brief and just mentioned quite a bit, is that the split rail fence is not the entirety of the fence. There's 100 feet of fences, and the portion of those fences that is split rail fence is only just a little more than a third. So out of the 100 feet of fence, 78 feet is completely on the Tyndall property, the defendant's property. 22 feet encroaches on the boundary line, and only a very small amount of that is actually centered on the boundary line. So to say that there's less than a degree of difference and of precise geometry is just not the facts of the case. The vast majority of this fence is completely on the Tyndall property, and no definition of the statutes could make that a divisional fence. The statute is very clear, 4743 is very clear that a divisional fence shall be centered on boundary line, and this is not even close to centered. The one thing that the defendants frequently ignore is the fact that most landowners put up fences on their own property, and that's perfectly permissible. So when we're talking about if the legislators a couple hundred years ago were thinking about whether or not fences would be exactly centered on the boundary line, most people don't do that anyway. They put fences on their own property. I have a fence at my own house. I'm getting a quote to have it repaired. It's completely on my property. It is not a divisional fence. The statutes just do not apply to it. So if you put up a fence almost entirely on your property, a little bit goes on your neighbor's property, it's a trespass. Yes, Your Honor.
Counsel, with respect to the issue of exhaustion, there was no motion to dismiss, I assume, raised before the trial court regarding exhaustion?
No, Your Honor, it was not raised as a special defense either.
Okay. All right. So it was not before the court, correct?
Correct, Your Honor.
Okay. Can you address the conversion issue to the extent that that issue was never pled, clearly not properly pled as conversion, and that I'm troubled by it, to be honest.
Yes, Your Honor. I would say that there are two very specific allegations in the complaint that relate to damage of the chain link fence. I do think it's fair for a trial court to interpret the pleadings broadly. There's an awful lot of case law about doing that. I can see why Judge Domnarski believed that conversion was the part of it there. Yes, Your Honor.
Can you identify for me in the complaint where the elements of conversion are?
So the mention of the damage to the property is in, the beginning of paragraph 5 and also in paragraph 11. It's actually a separate, 11 is a separate paragraph from the trespass paragraph, and to me indicating that there is a separate claim there.
But there isn't a request for damages, which is important, right? We need for purposes specific to conversion.
There's not a specific ask for damages as to the conversion. That's correct.
So wouldn't that fail then for purposes of stating a claim?
It certainly may have on a motion to strike. That was not raised. I would say that.
I'm sorry. The parties were not on the defendant was not on notice that conversion was being pursued here, or they would have asked to have that stricken, correct? Or I mean, they just weren't on notice enough to know that that was going to be something they would need to have stricken.
That could be, Your Honor. It wasn't raised beforehand. If there was confusion from the defendants as to what was being alleged in the complaint, they certainly could have done a request to revise. I do think that read broadly, it does show a conversion count because there's separate information about the trespass than there is from about the chain link fence. If Your Honors deemed that conversion was not pled appropriately, it would have to be looked at under the trespass lens because that's not something that Judge Demnarski looked at.
I don't understand. I don't understand what you just
Rather
said.
than looking at the chain link fence in terms of a trespass, he viewed it in terms as a conversion. So there would be no doubt that a trespass was certainly pled if that was the only remaining thing. So it would still need to be reviewed as a trespass.
But how does the damage to the chain link fence? All right, the damage to the chain link fence, which I understand is the removal of a post and something else, that there were damages awarded for that, correct?
Yes, Your Honor, there are nominal damages for the technical injury.
Right. So, but how does that get attributable to trespass?
I think it would be almost entirely the same argument that there was property that the plaintiffs had a possessory interest in. It was taken by the defendant, and there's a technical legal injury.
Counselor, are you basically saying that if we find that there was error on the conversion count, we have to remand to the trial court to have the trial court actually do something with respect to what you actually pled?
That could be what you determined to do. If it wasn't pled correctly as a conversion, then it would be our position that it was correctly pled as a trespass. I think that in terms of if we would want it to be remanded to the trial court just on the chain link fence issue, I would think that we would say no to that question because it's just for a nominal damage for a technical injury. More important to my clients would certainly be the removal of the fence, the split rail fence from their property. Yes, Your Honor.
Did the trial court order anything else with respect to the chain link fence other than the $50 in nominal damages?
No, Your Honor.
He didn't say fix it, restore
No,
it?
Your Honor.
Oh,
No.
I see. Okay.
But I guess what my concern is that there's a finding of conversion. I mean, that's not a small thing. Even if there are nominal damages, there's a finding of conversion as to these defendants, right?
Yes, Your Honor.
Okay.
The only thing I would say in response is that if the court felt like that conversion finding could not stand, I would just ask that if it's only going to amount to nominal damage for my clients to go to the trial court for to try it under trespass, that we would simply abandon that remand if that was what the appellate court wanted to do. Because the dollars and cents just won't work out for anyone in that.
Yeah, well put. Go ahead, Attorney Shulman. You still have
Sure,
time.
thank you. There's one other point that I would like to make regarding the split rail fence is that the defendants often point to the history of the statute, which, as we all know, the history and why it came about would only matter if it was ambiguous, which we do not believe it's ambiguous at all. But even if we looked into the history, which is keeping cattle out of land or trying not to destroy land that's been plowed, a split rail fence, just by its being, is completely open and keeps no children, rambunctious or otherwise, no dogs, no pets out of a neighboring land. So the idea that we can look to the history and that allows this as a divisional fence is fanciful, because a split rail fence does nothing that the fences that are deemed sufficient by statute do. Never mind the fact that there was no going to a fence viewer to say that this is an official sufficient divisional fence. Yes, Your Honor.
So, Counselor, at least with respect to just the split rail fence itself, do you agree with counsel's characterization of the extent to which it does or does not intrude impermissibly onto your client's land, and it's also its characterization of what the trial court found in that regard?
Yes, Your Honor. So if that split rail fence was a divisional fence, the type of, there's a few hurdles that you would have to leap, but if it was, it would be allowed to be centered on the boundary line so that half of it was on my client's land, which it does not more than half of it does not go onto my client's land. So if it were divisional, it wouldn't protrude too far into my client's land. The claim is purely that it just goes onto their land for such a small amount, it cannot be a divisional fence, and therefore it's prima facie a trespass.
No, but I'm trying to understand. Did the trial court find that the split rail fence itself intruded onto your client's land more than, would be permitted under the fence statute?
It did not find that it protruded more than would be permitted.
Okay.
That's correct. Just one other issue that's arisen in this case is whether or not Judge Tyndall could be held liable for trespass because she did not physically build the fence or evidently allow or okay her husband putting up the fence. He is referred to in the brief as a tenant. The fence is simply a fixture. If a fence gets put up on your property and it trespasses, it's your trespass until you do something about it. That's black letter law, and I don't know why we're still discussing that. Yes, Your Honor.
I just want to backtrack to the fence because your argument is it's not a divisional fence because the entire fence is one fence. And when you look at it as a whole, it clearly doesn't meet the requirements for a divisional fence, primarily because most of it is actually on the defendant's property, ironically enough. So, but what is that entire fence that is one fence? Because I see three fences. I see there's the split rail fence, then there's the privacy fence, and then there's the chain link fence. What is the fence?
The fence is 100 feet of fence from the back of the defendant's property to the street, basically to the sidewalk. The chain link fence is a separate fence, completely from that 100 feet of fence. That was the original fence that was in between. It's still standing. So we have the defendant's fence that starts in the back of their property. Then the chain link fence is directly next to it. My clients actually have their own privacy fence on their property on the other side of the chain link fence as well. So the 100 feet of fence for 78 feet is entirely on the defendant's property. And then it starts veering onto the boundary line and moving onto my client's property at the end. So it's 100 feet of fence. The distinction that the defendants have been trying to make is that there are three separate sections of fence because they were built at three different times, but they're all connected. The three fences that total.
So that's what I'm trying to understand. Where does the split rail fence, what does it meet?
It meets the 6-foot extension of the privacy fence.
Okay.
And it's connected to it. And that fence connects to the original privacy fence erected just on the defendant's property. So it's 100 feet total. Even if we looked at just the split rail fence, the majority of that is also not on the center line. So even that smaller 35-foot section does not meet the statutory definition. Yes, Judge Elbow?
I guess what I don't really understand is, but for my problem with the conversion count, I don't really see the chain link fence being relevant at all. It's just part of the story. But in the end, and so really, so really the issue is the split rail fence, because that is the part that starts in the Tindill's property and then moves into this boundary line, right? Okay.
Correct.
All right. Go ahead if you still have some time, I believe.
If there are no more questions, I don't need to belabor my points any further.
All right. I don't see any other questions from the panel. So Attorney Ziska, you have 4 minutes.
Thank you, Your Honor. With regard to Judge Tyndall's supposed liability for trespass, it's always interesting to me that the counsel for the plaintiff says it's black letter law. One of the things I pointed out in the brief is they've cited no cases. And when the judge found that Judge Tyndall was liable, he cited no cases. And it was never pleaded. There was never a plea in the complaint that she was liable as an owner of property. The complaint was that she caused the fence to be built. And when we submitted discovery requests, they had no evidence to prove that. So the complaint said she caused it to be built. They submitted no evidence. They came up with a new theory. She's liable as a property owner. They submitted no precedent whatsoever to support that. And the judge agreed with it, citing no precedent whatsoever. We believe that decision was wrong. I would also point out that we cited a variety of out-of-state cases. There are none in Connecticut we could find that indicate if you put a fixture on somebody else's property, it becomes the owner. They become the owner of that. They can decide what to do with it. Now, in this case, the plaintiffs say we want it removed, but I think their remedy is against the person who put it there if it is in fact a trespass, and that's against William Tindall and not Erica Tindall. Again, with regard to the fence, Your Honor, what I would say is the split rail fence, what I would say is the statutes contemplate that each property owner is going to have the same role to play in building a fence. And in fact, the statutes allow different fences to be built. The statutes would allow one property owner to build one type of fence for half the property line and the other owner to build one half the fence for the other property line. In this case, there was the chain link fence that occupied half of the property essentially, and William Tindall built the split rail fence and the extension of the privacy fence to essentially complete that. The question of whether it's a divisional fence, again, we cited several cases, Fox versus Beebe, Grosby versus Harper, Huntington versus Whaley, in which the courts have interpreted fences that don't occupy the center of the boundary line or are not centered on the boundary line, interpreted them nevertheless as divisional fences. So our position is essentially the thrust of the statutes is to create essentially a statutory easement. And under 47-49, yes, you're on, Judge Clark, I agree with you. It might have been better had the property owners agreed on what type of fence. Certainly that would have been better. Nevertheless, statutorily under section 47-49, it's clear that the statutes allow any one owner to take the initiative to build a fence. And then the statutes create the opportunity to go to the fence viewers to fix any problems that may exist as a result of the creation of that fence. And what we would say is essentially what the statutes are doing is creating a statutory zone of easement. You have the right to build a divisional fence within that area. And since you have the right to build a fence, at least partially within your neighbor's property, there's no uniform control by the neighbor. That property owner does not have complete control of that property. And under the law of trespass, you need to have unilateral control of the property to claim trespass, which they don't have in this case. So again, our point, simply put, is there was a statutory easement. William Tindall tried to create a fence as state law allowed within that statutory easement. If he failed in favor of the plaintiffs, and that the plaintiff's remedy should have been to go to the fence viewers rather than the court. One last quick point with regard to the issue of whether the court has jurisdiction. We couldn't claim that because, don't forget, this was on summary judgment. We couldn't claim that because until it was determined by the court exactly where the fence was, there was a possibility that the fence was actually further onto the plaintiff's property than even state law would allow. That fact hadn't been determined yet. So the court did have jurisdiction to find that fact. We couldn't raise it until summary judgment when the only thing the plaintiff had was their survey. Thank you, Your Honors.
All right. Well, thank you very much, Counsel. Oh, I'm sorry. Judge Cradle? All right. I wasn't sure if you said something. Okay. All right. Thank you very much, Counsel. I appreciate your argument. We appreciate your arguments, and thank you for participating in this virtual hearing. We look forward to seeing you in our regular courtroom sometime in the future, and we'll take this matter under advisement. We will now adjourn until tomorrow at 9:30. Thank you.
Thank you, Your Honors.
Thank you.